the important course, Indian Maritime Law and Ship Arrest. So far we have discussed with 4 sections. The last section 5, Ship Arrest over claims, now we are going to see. What is the meaning of ship arrest? Sir, person arrest means we know very well, but here the concept is totally different about what? Ship arrest. Yes. Enforced claim of maritime law against foreign ship. Arrest of Convention 1952. Arrest of sea-going ships. Brazil Convention 10th May 1952. International Conventions of Arrest of Ships 1999. Geneva also applicable in India. So both are no longer applicable in light of the enactment of most important enactment, Admiralty, Jurisdiction and Settlement of Maritime Claims Act 2017. So here we are going to see one most important act called Admiralty, Jurisdiction and Settlement of Maritime Claims Act 2017. Now, already I have told one important case. Likewise, there are 3 important case laws. One is MV Elizabeth and others versus Irvine Investment and Trading Private Limited. Second case law, Liverpool and London SP&I Association Limited versus MVC Success and others. Geneva Convention 1999 applicable for arresting a ship in India. Okay. But on what basis they may have right to arrest the vessel in our country by using either maritime claims, what we have discussed about the Jurisdiction Act 2017 as well as Geneva Conventions. There are various claims which are listed out. Based on that only they may have right to arrest the vessel. One is damage done by a ship. Point number 2, loss of goods in transit. Point number 3, salvage. Point number 4, master wages. Disbursement and bottomry irrespective of any change in the owner of the vessel. Change in ownership of the vessel, the claim failed. No arrest unless the fraud committed with respect to change of ownership. For all these points only, whereas the party may have right to what? Arrest the vessel. Okay. Previous point we have discussed about what are all the reasons. Okay, damage done by a ship, loss of goods, salvage, master's wages, a disbursement and bottomry, change in ownership of the vessel, in settlement of full claim. Okay, but just like that they cannot arrest the vessel. There are various documents is required for ship arrest. Claimant issue a power of attorney. It is very much important document on behalf of the party. One party only executing this property on another person who will have the power to sign all the necessary document. Okay, so note of appearance, attorney is very much important, or authorize a lawyer to act, appear and plead the case in court on behalf of whom? Claimant. So on behalf of claimant, if you are going to appoint a person, okay, authorizing a lawyer to act, not only act, even appear, even to plead what? The case in court on behalf of claimant. All these documents required for what? Ship arrest. Detailed facts of claimant. First point, nature of dispute, why they are going to arrest the vessel. Point number 2, particular of claim. In case with regard to claim means what about the details of the claim to be presented. Supporting documents. Original contract means supporting document. And type of vessel and document regarding what? Payment. All these points also it is very much important to be stated in the document. So now, prayer of claimant. I am the party who not yet received the claim. Now in such a case I can plead in front of the court. Okay, what I can ask, one is arrest of the defendant. The party who filing the case in the court, petitioner or plaintiff, against whom I am going to file the suit, defendant. So I may ask the defendant to be arrested, or sale of the vessel, or account of compensation, or I may have right to demand to pay some amount of compensation. So in such a case, prayer, I can order of court. Court can the court can order, see, I have put my request. Now court may order what? Arrest of the vessel. Judge sign the order arrest. Arrest will be issued by registry warrant. Here the other warrant which states another important one, to serve to custom and port authorities. So bailiff, an officer whose job is to take the possession and property of people who cannot pay the debts after serving the warrant of arrest to whom? Port authorities. Last one, affidavit stating performance. Okay, stating performance or performed his duty. Affidavit document which is also another important point stating whatever the statement which has been mentioned in the document, it is true to the best of my knowledge. Likewise, he should place all the points and at last put the signature stating what affidavit. Likewise, order of the court, judge signing or arrest will be issued by registry warrant, and the bailiff means an officer whose job is to take the possession and property of people who cannot pay the debts after serving what warrant of arrest to whom? To the port authorities. Next, Indian Council of Arbitration for Maritime Dispute. As I told, maritime dispute directly you need not to go to the court. While placing a contract itself, there is one most important point. There are certain settlement disputes can be resolved with the help of arbitration. So, domestic and international maritime arbitration in our country, which comes under Arbitration Conciliation Act 1996. Parties are free to agree the procedure followed by the tribunal. Okay, tribunal is a quasi-judicial body. So, these tribunal also to be formed to resolve the disputes between the parties. So, maritime arbitrators commonly administered by Indian Council of Arbitration. So, they will give some amount of time within the time limit that they have to complete the proceedings and proceedings to be submitted. The proceedings were followed with the help of arbitrator is called as arbitration proceedings. Arbitral tribunal, it is required to be passed the award within 6 months from the date of the reference as per the rule 10(4)(a). Court may intervene in case if the tribunal is request the court, then court may intervene. Okay, or to provide any assistance in taking the evidence, court may intervene. At last, Chief Justice of High Court or Justice of India may intervene to help with the constitution of the arbitral tribunal. So, likewise, arbitral tribunal is, as I told, quasi-judicial body. They are not going to punish. The most important point is what they should see that how to resolve the disputes with the help of between the parties for which the arbitration and conciliation. A private party will have been appointed here to resolve the disputes between the parties is called as arbitrator. Conciliation, labor disputes. Say for example, strike, lockout, layoff, retrenchment with regard to any issues happening within the industries among the laborers means conciliator will be appointed. Same conciliation also the same thing which will be happen. But conciliation proceedings is win-win situation. But the arbitrator is win or lose situation. Either one party should accepted, another party not yet accepted means again they should go to the court. But the conciliation always there is a procedure of employer and employee relationship is important here with regard to bonus. If they are doing the strike means mutual aspect all the times it may be applicable in what? Conciliation, but it may not be applicable in what? Arbitration. So likewise the arbitration, conciliation, but which one is very much important with regard to shipping industry means arbitration. So most of the companies where they are engaging in doing the services with regard to ship transfer, with regard to transportation, sea transportation means always they may enter with an agreement. In that agreement, specifically they will mention one point with regard to resolve the disputes between the parties, either with what? Arbitration, or the maximum times arbitration only, less amount of times only the court may have right to intervene in case any tribunal where they put the request to the court, or if the tribunal needs some amount of assistance or the evidence which is required in such a case, these tribunals can put a request with what? Court may involve to see that how to resolve the disputes between the parties. So likewise in this chapter we have discussed the various points about what? Ship arrest over the claims. Okay, so Indian maritime law and ship arrest, hope you all understood with section 1, 2, 3, 4, 5 deals with basic contract and what are the various types of contract, what are the various types of act, what are the various statutory regulations, how these regulations are involved, how these regulations are involved in proceeding with the ship arrest. Once the ship arrest means what are the various documents are required, what is the meaning of maritime claim and what is the meaning of maritime lien, and at last ship arrest over the claims. Likewise, the entire concept with regard to Indian maritime law and ship arrest we have discussed. Okay, hope you all understood, and with this we will conclude this course Indian maritime law and ship arrest. Okay, in the next session followed by Indian maritime law, we are going to see maritime insurance in detail with the help of the same course. Thank you all.